So this song I just played said, I've been working 6 days a week, wearing holes in the soles of the shoes on my feet. Who works 6 days a week?
You work 7.
Yeah. I mean, y'all do too. There's just no way around it because you're on call all the time. And then no discount at all. I just think it's kind of funny. But Kathleen sent this morning and said, happy Friday. It's a great day and have a wonderful weekend. And I thought, what the hell does it have to do with real estate? Friday is Monday and the weekend's just like Tuesday and Wednesday.
Yeah, you can have your own weekend of your choice any day of the week.
Well, that's what I wrote down. What? Let's discuss this because you are on call and you do have to schedule time. And even Zillow in their infinite wisdom says, we only expect you to answer the phone 50% of the time, right? So are you taking time off? I just schedule it, block it off, put your phone on pause and take a break because you will. I mean, those of you that are crushing it right now are going to end up with health problems if you don't take care of yourself. And 7 days a week is a lot, but you can work half days and you can work quarter days and it's all about your schedule. And that's not what today is about, but I just thought this is kind of cute. I said, Friday, have a great weekend. No, I got events planned all weekend, real estate wise, and so do you, and I'm available for you, and so is Deb, and so is Jimmy, and so is Chris, and so is Thomas, and so is Jeff, and so is Otis, and so is Joe, and so is Kathleen, and just everybody. We're all on call. So there's never a day off unless you take it, right? But when you're not working, don't work. Just a thought. I'd share that with you guys.
So Dick is going to Germany today for 2 weeks.
Nice.
My goodness, how's he doing that? Well, he's got great coverage. Thank you, Sandy Tams. Yeah. You know, so he's got somebody to help him. But yeah, he's taken off for 2 weeks to go see his son. God bless him, and he should. He's been hard at it this year.
Well, Dick's on track for Centurion, which is $280,000. So you know he'll take home $240,000.
Yeah,
you can afford to go to Germany, and I hope he's flying first class.
I do too.
All right, a couple of housekeeping issues I want to jump into. Move Easy is a big deal. And, you know, my biggest fear as a broker is getting adoption and implementation. So if you haven't done the real simple, you got an email that says, create your password, do that. And then you've got an account. Then you get an email that says, congratulations, here's your account. And now you got an account, but you've got no vendors. So go watch the class from yesterday and let's, I don't need to show my screen anymore. And go set up some vendors for yourself. This is a huge asset. And I'm going to jump into something real quick. I just stopped sharing my screen. I'm going to share my screen again. Good morning, Josiah. Thank you. Angelique sent this out. I think it was yesterday. It was yesterday. The Next Level Resource Center, guys, is going to be the Next Level Resource Center for you. And we're constantly adding to this. So Home Concierge right here, if you click on the link, this is very simple. It takes you to the Next Level Resource Center, which Angelique's doing a fantastic job populating. Yeah, and then here's the
she's put so much work into this. This is amazing.
Yeah, this is your go-to for everything that the company does. And she's going to send you reminders to log in. Now, if you click and you don't get a thing, then send an email to her and she'll make sure you're activated in the program. But this is just a little interview, just a refresher, right? What it is, if you don't know. And there's lots of these things that are going to be popping up. So back to here. So so there's the Next Level Home Concierge thing. And here's a Home Partners. If you're not familiar with Home Partners, here's a resource on Home Partners. And we brought up Divvy Homes as a counterbalance.
Yep.
To Home Partners. You should know what that is because you know my thing, Deb. What is it? Awareness gives you
flexibility,
and flexibility gives you options,
opportunities, and options and opportunities.
And options give you power. So if we it's our job to make you aware. So you got Home Partners awareness, Divvy Homes awareness, grab and go content, pre-made content at the ready from Century 21 with stuff you can do, social content pre-made on the ready, a script library. Some Next Level University topics. If you're confused about, you know, if I'm going to call FSBOs or absentee owners or use Remind, it's all in there, right? Then we have the Century 21 Resource, Century 21 University content which is really good. I did a class yesterday with, I forget his name, Jay something, but, just cool stuff at the take. Century One's doing really neat stuff. And then you got Workplace by Facebook. It's all stuff I want you to be aware of. So just take a few minutes and
You have an
click on the
abundance of
links.
learning for everybody on an ongoing basis.
You
Abundance of
100%
training, abundance of being able
do.
to learn more and more in this business.
Yes. So continuous
You're
ongoing.
muted, Craig.
I'm not muted. Can you hear me?
Nope.
Hello, hello. Test, test, test. My
Nope.
microphone says it works.
Nope. You're still muted.
I'm not muted.
Oh,
Your volume's down. It's not me.
I'm good.
Everybody else can hear you.
I can hear. It's, yeah, my TV turned off. Oh, I'm hooked
Yeah,
to it.
now it's really loud.
Yeah.
Okay, ongoing master's level education. I'm going to share this with you real quick. Just this stuff that comes across my thing that, thank you everybody for replying that you could hear me. Sean from Paramount Title, the Hillsborough Title Network of Companies, sent me this yesterday. I thought it was eye-opening. And once again, my chant here is awareness. So I will share my screen just so you know I'm making this up. And from Sean, friends beware. Listen to the crap that goes on. So this came from a FIRPTA lawyer who does business with our title company. Friends beware. Recently, our company was approached by a Norwegian citizen looking to sell a property in the Cape Coral area. As a foreign seller of US real estate, he was subject to the Foreign Investment in Real Property Tax Act, right? And required our assistance with all of the IRS tax forms. During our initial interview process, he provided his Norwegian passport for identification purposes. That's okay, he's a Norwegian citizen. But he gave us a Nigerian phone number for communication. Interesting, not a problem, just aware. And mentioned that he had a bank account in Singapore. Okay. While this information may seem innocent to the unsuspecting recipient, it was an immediate red flag for us. We examined his passport copy again. It appeared to be legitimate. It had all of the usual security features, correct image size and consistent fonts. Fortunately, Norway allows you to look up passport information online, and sure enough, his passport was a fake. Between the stolen identity and a few other rookie mistakes, it was clear that this was not the real property owner. So here's a foreigner trying to sell a piece of property and get the money. I immediately warned all the parties involved, and we agreed this should be reported to the FBI. Sadly, this was not our first encounter with a foreign imposter. In fact, this is our 6th case alone this year. I reached out to some industry colleagues to see if these were isolated events. I was troubled to hear that many of the title companies we work with, that these types of fraudulent sales are happening on a daily basis. In an effort to combat these fake transactions, here are some tips and red flags to look out for. Request proof of ID up front. If you are not trained to spot forgeries, send a copy to our office for review. Request to do a video conference call to confirm the person's identity. If they don't agree to a video call, that may indicate a problem. Compare addresses and phone numbers. If the deed says they live in Germany, but their phone number starts with a different country code, that could be a warning sign. Send the seller a document for an electronic signature to get their IP address. Does it match the country they said they are located in? I don't even know how to do that. If you've ever had a client tell you they don't care about FIRPTA and don't want their money refunded, that should be a huge red flag. Oh, we don't care about FIRPTA, just withhold the money, because it's not their money in the first place. I'd rather have 70% of something than nothing. Some of these ideas may seem like a stretch, but these criminals will stop at nothing to manipulate you. My hope is that these crime organizations get caught and the victims find a way to get their properties back. Until then, all we can do is spread the word and be extra cautious. I just want to put that out there because awareness is the key. And this stuff happens. And, we have fraud attacks on our wire transfer funds, like still daily. That's why every title company you read now has a message at the bottom of their email signature that says, please verify wire instructions. Most banks have please verify wire instructions. That's important stuff. So once again, I want you to be aware of that.
Yeah,
So,
we had a listing that we had for a very short time this year, actually a couple months ago. And the documents came up, we had a look, because there was a transfer in the deed 2 days before the seller passed away. It was a quick claim. Okay, you know, that's a little bit of a red flag, but maybe not. But as we got digging deep into it, and I did send it to India, and she sent it on to their law department and stuff, because it was just weird, because there was only one signature. The signature was misspelled. That was the first key. There was a misspelling. And when we started digging deeper, these people had taken quick claim over 3 other properties in the last year, all fraudulently. And it was when somebody was on their deathbed, they went in, they forged a quick claim. And when you look into the website in Hillsborough County, after, you know, Paramount Title looked it over and everything, it was like, this is wrong. There's something totally wrong in here. It's not set up right and properly. As far as a deed in Hillsborough County, there is some really misinterpretations. So we pulled out of it because the listing was fraudulent. We could not really sell the property at that point. And so I let Paramount really take over and hopefully turn them over, because it was a fraudulent way to get a property from somebody. Yes, indeed, the person that owned it previously passed. 2 days prior to them passing, they supposedly signed a quitclaim deed, and in reality, they really didn't. That's another way. That's what we're seeing too, which was weird, very weird, but it's happening out there.
so why is that important to us? What if we listed that property?
Now we had,
And we would have made a profit. We would have made a promise to the cooperating broker that if you bring me a buyer who's ready, willing, and able to buy at the terms of our listing agreement, what do we owe?
commissions.
We owe commissions to XYZ Realty.
Yeah.
And are we going to get a commission from the seller? No.
Because he wasn't really the seller. He had no legal right to sell the property.
Mhm.
And it was just all these little red flags kept sort of coming up. And yeah, it's a really bad little scheme going on right now.
No, we can live in our happy little world, but fraud is real and it's going on. And we are expected to know what they are. So again, thank you guys for tuning in. Okay, I've got a couple case studies I want to play around with today. And a lot of this is going to be repetitive, but our job is to empower, educate, and encourage. Right. And we are the calming force. And that's why we're here, because, you know, what's my saying from my Vistage group? It's hard to read the prescription when you're inside the bottle.
Yeah.
Right. I can't read what this says when I'm inside the bottle. So we can teach you all this stuff, but when it really happens to you, you go, oh shit, what do I do?
Mhm.
So it's not uncommon when I get a question like a voicemail. Hey, Craig, I've got a real big problem. Give me a call. And I go, okay, well, what is your problem? And the problem goes something like this. Turn this off. Where is this one? So I answered, and I'll tell you a long story short. So when I was a young man, young child, a teenager, my mom and dad took us on a cruise with a group called YPO. And they had a speaker. I'll never forget the speaker. And his topic of the event was, guess what, now what? And the concept was, there are no problems in the world. Guess what? This happened. Then you make a decision. Now what? Guess what? My buyer says he's not going to close. Okay, now what? So our agent called me and said, I've got a big problem. What do we say? And I go, okay, well, what kind of contract is it? It's an as-is contract. Great. Is it conventional or FHA? It's FHA. So we had an FHA contract. When's the effective date? So what do I do? When people get into emotional bad places, where do you want to take them?
To the contract.
You want to take them to logical, because they flap off and they get kind of wacky, right? So you take them from, hold on, I got to get to where I'm going here. You take them from emotional bad to logical good. So the agent's freaking out. They're afraid they're doing something wrong. It's all the world's coming to hell in a handbasket. We're going to jail. It's a big problem. Let's solve it. So I take them to from emotional bad to logical good. And logical good says, okay, what kind of contract is an as-is contract? Good. I got that one. Financing is FHA. Cool. I know what that means. When's the effective date? I'm asking logical questions. The effective date was July 19th. Okay. When's the loan approval period up? I don't know. It didn't say. Okay, it didn't say. Well, the contract is pretty smart. When there's a blank, it says
It defaults
defaults to something, and loan approval defaults to when?
30 days.
30 days. So we're still in emotional, logical good here. So we got a loan approval of 30 days. What's today's date? It's August 26th. Is that before or after July 19th? It's after, it's more than 30 days after July 19th. Yep, it's after 30 days after. So what happened now? Where loan approval passed, the buyer didn't cancel. What has the buyer done?
The buyer now has had the right to cancel prior to that loan approval period. If they didn't, it defaults now to they waive their contingency for loan approval and they waive their contingencies for appraisals.
Yeah, their financing contingency is waived. The
Yeah,
contract.
everything's waived.
Then, okay, so we got that. We've already granted them one extension. Now that brings a question, right? Because we grant an extension of the closing date. Does the closing date extend the loan approval date?
No,
No. How do you extend the loan approval date?
you've got to write it in the.
You got to write it in,
You gotta
right?
write it in.
So when you're the buyer's agent and you do a closing date extension, you might want to consider doing a loan approval date extension as well, or else you're just moving the closing date, but you didn't extend the financing period.
Yeah.
So see, when you get to the logical side, it's calmer, right? And then I asked, how much deposit is up? And the answer was $10,000. Great. How much additional deposit is there? Oh, we didn't get any.
Yeah.
Oh, we didn't get any. Why not? Well, I thought 10,000 was enough. Guys, time out. $10,000 is not enough. The whole purpose of an additional deposit is to signify to the seller that the buyer intends to go forward after the inspection period. It's a little confidence booster. I don't care if it's $1,000 additional deposit. This is an FHA deal. We're only putting 3.5% down. So how much cash are they going to need, right? But it's the significance of making the effort after the approval, after the inspection period, to say, hey, Mr. Seller, I'm okay with the condition of your property. That's why you want the additional. I don't care about the money. I care about the significance of, hey, seller, I'm in, dude. We're on the same team. We're moving forward. That's worth more than the deposit. All right. So there's no additional deposit here. So we don't have a good, warm feeling. And now it's the day before closing, and the buyer finds out they can't get their gift funds.
Uh-oh.
Guess what? We're not closing tomorrow. We get to logical good. What are all these facts? Okay, buyer can't get their funds. So now what?
Could the buyer be in default?
The buyer,
Because everything was waived.
they will be in default
Yeah, it will be in default.
when they don't close. So now this is where emotions come in. We're attached, right? We want our closing check, our commission check for this closing. The seller wants their proceeds check. The buyer wants their new house, but shit happens. Guess what? You can't get your funds. Now go borrow from, it was Uncle Joey, now go to Aunt Sally, or mom and dad, or brother, or neighbor, or fraternity, get the money from somebody, or you're losing your $10,000 deposit. That's a pretty stiff penalty, right? And I don't want to be a cold. HUD steals the buyer's deposit. HUD doesn't steal anybody's deposits.
No.
John, what do you mean FARBAR force dates were based on each other? Oh, you gotcha. Yes. You're saying loan approval and closing date was used to move with each other in the previous versions of the contract. The new version, FARBAR 5, it does not. Loan approval has its own date and closing date has its own date. And if you want to move both, you got to move both, not just one.
Yeah.
Good memory, John.
That's the biggest mistake most agents make, is they forget
100%.
to move that, that commitment, the loan commitment, everything else.
Because they operate over here on emotional craziness, but
Yeah.
come over here to logical calm and you'll slow down and get it right. Right. So, I try hard. I really do have a heart. I don't like people to know that.
But you do.
I do. And I don't want to keep their money, but the facts are the facts. You took my property off the market. Now in this market, it's probably better for the seller to cancel, put another buyer in there, get more money, because the property's probably gone up since they went under contract 30 plus days ago.
Yeah.
Which is not always the case, by the way. It's just crazy.
Yeah, so what does the contract on the loan commitment do for the seller? It tells the seller, you don't get notice from the buyer of a loan commitment prior to loan commitment date. The seller can cancel this.
Within 2
Oh.
days of
Within
the
2
buyer
days.
not
Yeah.
removing their contingency, the seller can cancel. After 2 days, they can't anymore.
Yeah.
So it's
But-
like, look, I don't feel comfortable with you, Mr. Buyer. You said you were gonna give me loan commitment by yesterday. I don't feel good that you're making an effort. You're not giving me any confidence. I've got another buy. I had 7 offers on the house and some were better than yours. I tried to give you a shot, but you're not making me feel comfortable. So I'm going to cancel you now, give you your money back, and I'm going to sell it to somebody else.
Yep.
That's harsh, right? But
Yep.
it's fully within their rights in this contract. And I would suspect, and this is my rant I'm going to go on in a minute. Most agents don't understand this.
That's true.
And it's no fault of theirs because most agents work for a broker that doesn't have any experience or doesn't have the legal background to know what goes on in these contracts. And it's a mess, right? And I'm just, that's my rant. So I guess I'll head into that. So what do we do in this case? Let's close this one out. So agent, emotional, whoa, big problem, bring it down to lot. There's not a big problem here. There's a $10,000 deposit. Now, Deb, this is a big one. $10,000 deposit. How much does the seller get?
Half.
Thank you. So agents, stop right now, time out. Good news, seller, you're going to get $5,000 because this buyer canceled. And then we're going to get $5,000. Beggins Enterprises, we're going to split our 5 with buyer's broker.
Right.
The $2,500 to buyer broker, $2,500 to seller broker, $5,000 to seller. Put the house back on the market, sell it again, and we'll get another commission. Right? I would do this like every week if I could. Get a big deposit, keep it, sell it to somebody else. Get a big deposit, keep it, sell it to somebody else. Get a big deposit, keep it, sell it. I've done this 2 or 3 or 4 times in certain houses. The sellers are real happy and so are we, because you get paid your commission on the retained deposit as well.
Yep.
So is this a big problem? No, you're going to get a share of $2,500 for some of your effort, and you're going to keep the listing and put it back on the market. If you're the buyer's agent, at least you got your $2,500. Now, many times the buyer's agent will share their ill-gotten gains with the buyer to keep the buyer working with them. But sometimes they don't. The buyer's not entitled. If the buyer's not going to move forward, then why share your deposit? You've got paid.
Buyer does have to sign off on that release, which is also sticky sometimes.
Yeah.
Because they're pissed off. They don't want to lose their money. And then what?
Well, it's not, well, it is their fault. They promised that they would get a loan and they had the opportunity to cancel within 30 days of loan approval, and they didn't. But did their agent advise them of their rights? What tool do we have, Deborah, to advise them of their rights and obligations?
The contract.
Critical date timeline.
Critical date, yeah.
Right? If you do a critical date timeline, it says, hey, buyer, your initial deposit is due here. Your additional deposit is due here. Your loan approval is due here. Your closing date is here. Your flood insurance inspection is here. But boom, these are your rights and these are your obligations. Have that conversation with them, right?
Share it with them.
100%.
Because they don't have it. Most brokerages don't even have a critical timeline for their agents.
No, that was experience. John, you bring up a very good question. Question is, can we go back on the market? So we're in a, hold on a second.
We're in an escrow dispute now.
Can we go back on market and sell if previous escrow is not signed by parties? Okay, this is an open-ended question that I'm going to give you our open-ended answer for. Jim Holloway, the attorney, says, yes, we can go back on market. We cannot accept another contract, right? This contract with the failed earnest money it's still a contract. The money has not been released. The contract has not been canceled. So there's an alleged right. The contract provides a right and an obligation to buy and sell. In the absence of a cancellation of that contract, we can't arbitrarily decide that contract's not valid. We need a cancellation of that contract. We can put it back on the market. But when we put it back on the market, write this down. We say to the lister or buyer's agent, in an effort to mitigate the seller's losses, we're putting the house back on the market. right? Because what we have here is a conflict. We have a conflict between the buyer and the seller. The seller is damaged. This buyer said they were going to buy the house on August 27th. Today. They're not. So now the seller is going to own it from August 27th on when they didn't plan to. So what's going to happen? They're going to make a mortgage payment they didn't plan on making. They're going to pay taxes they didn't plan on making. They're going to pay for insurance premiums they didn't plan on paying for. So they're damaged. The house could sell for less than they originally sold it for, which would add to their damages, right? All this stuff would add up to damages. So in an effort to, now the longer this goes off the market without being sold, the more damages the seller is going to incur. Does that make sense?
Mhm.
So to mitigate the seller's damages, we're going to put the property on the market ASAP. And that's really to benefit the buyer, because when we prevail and win, we're going to sue the buyer for our damages. And our damages of 6 months being off market are greater than our damages of being 3 days off market if we sell it again real quick. So the language is, in an effort to mitigate the seller's losses, we're putting the house back on the market. We're just notifying the other agent that in an effort to mitigate the seller's losses, we're putting the house back on the market. Now we can put it on the market. Now, if we sell it, well, we can't sell it because there's a claim against the title of that property because there's an open contract here. So what we would do is say, seller, here's the deal. We have a buyer who's looking pretty strong. Do you want to give buyer number one his deposit back and get that cancellation so we accept this contract? Or do you want to just sit there and prove your ethical point to buyer number one and lose buyer number two? You follow me there? We can't go sell the house while that contract is still not canceled.
Okay,
But
so
we can't put it back on the market.
yeah, John asked, so what if we get to closing date and it doesn't close? And so now they're in default. Can they put it back on the market and sell it?
Last I checked, I was not, nor are you, judge and jury.
Okay,
The buyer may have a side of their story that we are not aware of that might give them some rights that we're not aware of. The title company won't close it. Right? They're not going to pass clear title where there's still a contract out there. Now, you could probably find a title company that'll do it because they don't know about contract number one, but now you're a party to commit fraud.
uh-oh.
So whenever those words come into play, I don't really like it a lot. All right. So these are the facts of the way things work. Right. So the contract goes once past, yeah, once the closing date happens, yes, everybody's off. But if the seller did something devious or not proper that the buyer has issue with, that the buyer could make a judge feel their side was accurate, there's nobody going to make that decision. We need a cancellation from the parties in order to pass clear title.
Yeah.
That's what most prudent title companies or closing agents are going to do.
And sometimes we're good to get Jim involved if we're doing the closing, because he'll call and be logical to the buyer and seller and try and split it. So everybody goes their merry way. A lot of times, you know.
Well, I'll share with you. Jim has, my opinion, Jim is kind of tired of the same stupid questions over and over again. And I don't mean to say it in a rude way, but he has become very ornery, if you will. He's not kind. It's like, really, again, you guys haven't figured this out yet. He doesn't realize that it's a big issue to you, even though he's heard it 4,000 times. It might be the first time you've heard it. And he's the same way lately with buyers and sellers too. So I need to talk to Aaron about that.
Oh, okay.
But yes, he is a resource, but just understand he's going to be kind of short. And this is like I am here. I'm trying to show you both sides. This is not a big problem. It's a matter of fact. The buyer didn't close. They're going to lose their deposit. But now what happens? See, we can't be judge and jury. And you can't just, sorry, I've decided you're guilty. You don't have that power. And that's why the contract's such a mess.
Yeah.
When you have disputes and agreements. Okay. All right, Deb, I know we want to get to trust and stuff. I got one more issue, and this is just me being pissy, but I just want to do it. So an agent has a problem. Let me see if our agent's online. Yes. Okay. So once again, awareness gives you flexibility, flexibility gives you options, options give you power. And another statement, you can write this down as a Craigism: bullshit baffles brains.
Yes.
All right. And this is just me going on. A real estate salesperson goes to school for 63 hours, passes a school test, sits for a state exam, passes the state exam, and they've got a real estate salesperson's license. There's no requirement to do a listing presentation, make a listing happen, sell a house, work with a buyer, write an effective contract. You're a real estate salesperson, boom. If you're a real estate salesperson for 2 years, you can go to school, take a 72-hour course, not a 63-hour course, pass the broker's exam, sit for the state exam and get a broker's license. You still never sold a house. You've never worked with a buyer. You've never done anything, but now you're a real estate broker. And then you can go hire an agent and you can impart to them all the wisdom that you have, which is none because you've never done a friggin' transaction. All right. So that's happening. It makes me sick. I could go right now to MLS and sort by listing broker. And these are fly by night, just started companies that have no real experience. And they're hiring agents because they're friends. And we got to remember the average agent does 2 or 3 transactions a year. And they just don't have the experience to do it. But they're out there with pen in hand, writing contracts, or digital computers in hand, writing contracts. And what contracts are they writing?
As is.
As is contracts.
As is.
Okay. So, I mean, I don't know how to explain it any other way. As is means as is, right? Subject to your inspection. And when you inspect the house, you take the onus of saying, I've inspected the house. It meets my criteria. I'm going forward as the property is, period. There's no wiggle room in this, right? But listing agents are just as guilty in most cases as new agents, because they're new agents and don't have the experience, and they're attached to the outcome of a successful closing. So they waver on the strength or the value of an as-is contract. So Deborah, I buy your house as is. I make my offer to purchase your house as is. You as the seller have the right to expect that I'm going to buy it as is if I pass my inspection period. You're not expecting to make repairs or do other things to the contract. Right? That's what as is means. 100%. There's no, I'm not making this shit up. That's what an as is. When I started doing real estate 30 years ago, yeah, John, it depends. It always depends. Yes. As is was a scary thing. You never bought a house as is. When I started doing real estate, caveat emptor was in play. Remember caveat emptor, Deb? Mm-hmm. Buyer beware.
Buyer beware.
Buyer beware. The seller's agents represent the seller in this transaction. Buyer's agent and seller's agent represent the seller. Buyer beware. Caveat emptor, as is. We had no disclosure. Disclosure rights didn't come into 1986 when Johnson versus Davis got enacted. That gave the seller the obligation to disclose all known defects. Prior to that, there was no obligation for a seller to disclose. Right? 1986, that was 14, 20, 30, 35 years ago. Wow. Crazy. Wow, that is crazy. 35 years ago, and I remember it. Whew, I just graduated high school. Crazy. All right, so you've got inexperienced brokers teaching inexperienced agents to use an as-is contract, and they're running around like gypsies doing this shit. So here, our agent has a contract. It's a $700,000 house. The buyer's agent did a good job making an offer on a house that was accepted because they gave 0 inspection period, all the stuff a seller would really want to accept, but they really disadvantaged their buyer by doing that. To buy a house with 0 inspection period is stupid. Dumb, right? Unless you did your inspection prior to making an offer, which is not a bad idea. Invest the $500, get your inspection before making your offer, then go with 0 inspection period. But don't do it until. That's insane, especially with an older house.
Yeah.
So house is under contract. Buyer's agent did a good job writing a really strong offer. And then they come back and they retrade. And that's your fault, listing agent, for allowing it to happen. I mean, I got some big hammers in my garage and I know how to swing them, right? When you come at me with an offer that's that strong, no inspection period, over full price, closing fast, no finance contingency, 15,000 over appraisal, all that shit, you're telling me you want the house. I'm going to hold you responsible for that desire, right? But here the agent comes in, and this one really gets me. And I fell for a loss on this, and I want to share because it happens to me too. I mean, I know the contract inside and out, but I second guess myself because I know both contracts. So this buyer has a $20,000 deposit up. They've already asked for one extension, and we gave them one. Now they want another extension. And get this, they recognize that the seller did not patch the nail holes.
Oh
And
my,
they want a $1,500 credit
for nail holes.
for nail holes. Okay, so now let's get this straight. You're a buyer's agent. You've got a contract, not contingent on financing, to close today. You're asking for an extension, which you're not entitled to. You're already at sufferance with your loan approval period, so you're going to lose your $20,000 deposit. And your agent doesn't have the cojones to tell you, don't ask for an extension and don't ask for friggin' nail holes to be patched, when we can keep your $20,000 and we can put the house back on the market. We had 7 other offers to take. That's a problem for the buyer's agent not to have enough muscle to go to the buyer and say, you are lucky to even get this house. Don't press your luck.
Yeah.
Right. That's probably the agent who suggested these things. Well, you know, but they didn't patch the nail holes. How rude. We'll just ask them for a $1,500 credit. I wouldn't give you a $1,500 credit. I'd keep your $20,000, slap you in the face, and move on to the next buyer is what I would do. But that's an attitude. And I've been talking for the last couple of weeks now on these Fridays with attitude and strategy. The strategy is knowing what your rights are. Right. So I went to the contract with our agent and said, Brian said, my last listing buyer's agent is being mentored to do offers and transactions this way. Yes, because their friggin' broker has no experience and their agent who's mentoring them has no experience, and they're fools. So yes, raise the price. What I told our agent is, oh, you want an extension? Great. Give me an additional $10,000 deposit. And I want the initial deposit of 20 and the additional deposit of 10 released to the seller. And our agent had a hard time getting that through their head. Why do you want it released to the seller? Because the promise of a deposit is different than the release of a deposit, right? A $20,000 deposit, if it fails to close, yes, the seller's entitled to it. But will the title company write the check to the seller? Not without a release and cancellation signed. So you could put $1 million up, but if I don't sign the release, you ain't getting it without a fight. Do you want to get it without a fight, or do you want to get it with a fight? You want to get it now, or do you want to get it maybe 6 months from now? And I write this in my emails a lot when I'm writing you guys back. He who has the gold makes the rules. When you're the listing agent and you're in this situation we just went through, your closing's imminent, you got $20,000 at risk. I would rather put 10 grand up to save my 20 than to not put 10 grand up and lose my 20. And I'm losing, you're losing your 20. Now, maybe the agent didn't tell the buyer they're losing their 20, but they're losing their 20, right? The contract is really clear on that. They didn't cancel their loan approval period. They're gonna miss their closing date. They got no right to ask for friggin' nail holes to be patched. And we're gonna look at that in a second. There's power in knowing what these things mean.
And Craig, you know, this just happened this week. We had a buyer's agent, because we went back, very similar situation. And we had, the buyer needed to hear some bad news that they were going to lose their deposit if they canceled, because we were past the approval period and everything. And so we sent over an addendum stating put $10,000 up and we'll move forward. The buyer's agent came back to our agent and said, I can't tell the buyer this. They'll be mad at me. And it's like, talk to the broker then. Call them.
Then go lie to them. Lie to them then.
Yeah. And it's like, they can't not put this through to that buyer and help them understand what's going on. And we're seeing a lot of that. These buyer's agents that are new in the business are too afraid to even talk to their buyers to really strategize or do anything. They just want to collect a check, basically.
Yeah.
You know,
And they don't take responsibility for their actions. And that's a big
they don't. Not at all.
Okay. Lauren wrote, include an inspection contingency release. That's good advice, as well as the inspection clause when you're, yes, 100%. But Lauren, that still does not authorize the escrow agent to release the money to the party, to the seller, because the buyer has to sign a cancellation. So to get around this whole question of whether the deposit's released, have it released to the seller at the time of, it's real simple to write.
Yeah,
Buyer and seller agree the closing date shall be extended till August 27th as consideration for said extension. Buyer authorizes escrow agent to release the deposit, the initial deposit, and the additional deposit for a total deposit of $30,000 to seller upon execution of this document. Done. Now the seller gets a check for 30 grand. And if the buyer doesn't close, seller's got 30 grand. We put the house back on the market. We sell it for more or less or whatever we want. Well, no, see, I just caught myself there too. Seller doesn't get 30 grand.
we split it.
Seller gets 15 grand.
Mhm.
We get 7,500. Buyer's agent gets 7,500. What buyer's agent does with 7,500 is their business. What we do with our 7,500 is our business. And I say it's entitled to go into your pocket and mine,
Yep.
for the companies.
Yeah.
Right? You're entitled to it because you did the work. The seller was enriched because of your activities, your skill, and getting an additional offer and an additional deposit, initial deposit and an additional deposit.
Yeah.
All right. So now, but we want to be sure, Deborah, are nail holes covered? Is the seller obligated to patch nail holes
No,
on an as-is contract?
no.
There's a
no
maintenance-
obligation for repairs.
There's a maintenance provision
Mhm.
that says the house will be maintained in the condition it was when you saw it. So were there nail holes in the house when you saw it?
Obviously,
So I could argue, if I was going to be a
Possibly.
litigation lawyer, Kathleen will like this, I could argue that I'd be breaching my duty if I actually repaired it because I promised to give you the house as is. And when you looked at it, there were nail holes. And if I patch the nail holes, I'm not giving it to you as is. How about that for circular
I
logic?
like that. I like that. Yeah,
Okay, so, but our agent still said, but nail holes, how do I tell the buyer's agent nail holes aren't covered?
it's in the
Well,
contract.
nail holes aren't covered. It's not though. And so this is where I got lost saying, shit, as is contract, I'm telling the agent, I'm on the phone, not at my computer. The agent's at their computer, looking at the contract saying, nail holes, where's nail hole? I'm doing control find nail holes, find me nail holes. I can't find nail. I know nail holes is in the friggin' contract, but it's not in the as is contract. Why would they put nail holes in the as is contract? They wouldn't because it's as is. It doesn't have anything about cosmetic or warranted items
Nope.
because it's an as is contract. There are no cosmetic items. There are no warranted items because it's as is. People don't get this. I'm going to drive this home until you guys get it really, really, really hard. Maintained and broomed, swept. Yes. There is no provision for anything in an as is contract. You're buying it as is the day you sign the contract. Period. If there's nail holes, you get the nail holes too.
Yeah, there is no provision for broom swept. No, there's not.
That's right. It's not broom swept. It's just personal belongings removed.
Yeah.
I don't have to clean under it. You move the refrigerator, there's dust balls and
Yeah.
mouse hair and shit. That stays. The refrigerator's got to go, but the mouse hair stays. Gross. There's probably just remove the personal property in the trash. Well, maybe mouse hairs would be trash. All right. So let's look at the contract itself. The purchase and sale contract, not the as is one, just to drive the point home to the buyer's agent who with my wand, I've cast aspersions on that they're an inexperienced newbie who doesn't know the heck they're doing. Just to drive my point home. All right, paragraph 12, property inspection and repair. You've got an inspection period. You've got general inspections and repair. Interesting. Then you got property condition, which goes into define warranted and non-warranted items, which are considered cosmetic conditions. Cosmetic conditions means aesthetic imperfections that do not affect the working condition of the wall. If there's a hole in the drywall, does that mess with the integrity of the wall?
No,
Is the wall operating in the manner in which it was intended?
yes.
Yes.
Yeah.
Cosmetic conditions means aesthetic imperfections, but not limited to. This is the regular contract. Notice down here it says
Standard contract.
FAR bar 5X, not 5X as is. FAR bar 5X.
Size of the hole.
So cosmetic conditions defined below, unless the cosmetic conditions resulted from a defect in an item seller is obligated to repair or replace. All right, so there's a stain in my master bedroom ceiling right now. Do I have to fix it?
Is it wet?
No, but it's a result from a roof leak.
Okay. So it's
So now
dry.
what? So if I fix the roof leak, the stain is a result of the improperly maintained roof. So I would have to fix that cosmetic condition. Means aesthetic, but not limited to pitted marcite. Every pool has pitted marcite. I just redid my pool a couple years ago. It's already got pitted marcite again. Tears, worn spots, and discoloration of floor coverings. Wallpapers or window treatments. Nail holes, there it is. Nail holes. Nail holes are cosmetic. Scrapes, scratches, dents, chips or caulking in ceilings, walls, flooring, tile, fixtures, or mirrors, and minor cracks in walls, floor tiles, windows, driveways, sidewalks, pool decks, and garage and patio floors. Cracked roof tiles, curling or worn shingles, or limited roof life shall be considered defects, shall not be considered defects. Seller must repair or replace, so long as there's no evidence of actual leaks, leakage, or structural damage. Nail holes right there, but it's not in the as-is contract, which is what governs ours. So what? Now, I think it was the same house. It might have been a different one, but it was an as-is contract, and there's a piece of trim missing on the floorboards. The buyer wants the seller to replace that trim. Is it required? Was the trim on the house when the house got shown, when the contract was written?
If it wasn't,
No.
it's readily observable. No.
Yeah, your inspector has the right to move the friggin' credenza, and if there's no trim behind it, you're not getting trim because it's as is.
Mhm.
Now, I could argue if it was a regular contract, that would be a warranted item because there's trim everywhere else. There's no trim here. I'm not saying it's true or not true, but it would be at least an argument to look at. Why are people texting me during training, unless it's regarding training? Okay. Isn't that crazy? We're just trained to react to text like they're super important, but they're not. They're no more important than an email. And I'm sure I've got a bunch of emails coming through. I do. I got 7 in my personal and 9 in my inbox that have just come in. All right. So that was it. So nail holes. I just want you guys to just stand up and understand what an as-is contract means and then take control. Don't be a jerk. All right. I mean, there's a difference between, you know, being an asshole and being kind, or I don't know. A black belt doesn't go around beating up kindergartners just because you can, right? So I want you to be a ninja badass with the knowledge of the contract, but I also want you to be kind in the implementation of your knowledge, right? So you're not making them feel stupid. I want you to be sympathetic. Oh, poor little agent, your broker doesn't know shit. They didn't teach you right. It's not your fault, but I'm going to teach you right. This is an as-is contract. You got no ground to stand on. You want an extension? Good. Give me an additional deposit, make them all non-refundable, or I'm not giving you your friggin' extension, period. Now, of course, your seller is instructing you to do this, right? This is not Deborah wielding her sword saying, I'm going to protect you, seller. Your seller is instructing, you're guiding your seller to lead you in this direction. But if they don't lead you in that direction after you coach them, then you don't do it, right? You can recommend it, but they might want to keep happiness between the parties and not be a jerk.
Yeah.
Or
And actually,
might want to flex your muscle and say, no, I want you to march on this line or I'm not going to go. And there's a fine line.
it's a real fine line. So if your seller's hot water heater is going out and they find it on the inspection and it's as is, but you've got a really good buyer in place, putting 30–40% down with a conventional or cash, wouldn't it be prudent to go ahead and fix it if they ask for it? Because what have you got? Unless you got a backup contract out there, maybe you're still going to have the problem if this buyer goes away. And now you've got to disclose a hot water heater that's bad. You still got to fix it. You know, so maybe let's keep this buyer in place if you do not have a backup. That's a big caveat there. Yeah. But you know, be smart on this and understand if something is going wrong and that you didn't know about, the seller didn't know about, talk to the seller about, you know, do you want to keep the buyer in place? Let's get them happy. It's going to cost you $1,000. Okay. But you're getting, 10,000 above full price. Do you want the buyer to walk because you're not fixing the hot water heater, or would you like to keep them in place? So, that's where a lot of times I would go if we don't have backups. If we have backup offers, it's like, bye-bye.
Cheryl brings up a really good point. Okay, so I'm giving you the world according to Craig, just so you know. And I'm right, just so you know, but not everybody agrees with me. So Home Partners of America makes offers on as-is contracts, yes. But then after getting the sale, they go back to the seller to have them make repairs. Sometimes. When I pointed out the fact to them, they said that the as-is contract is the only one they have for all of Florida. I told them that we had a bar contract, but they said that some areas in North Florida don't use that. Is that true? Yes, it's definitely local in nature. Like Miami, they don't use as-is contracts. They're smarter than that. They have contracts that have repair limits, and that's just it's an abnormal. Foreclosures go as is. Why? Because the stigma is they're worth less, right? Deborah, if you go to buy here, pay here on the car lot, buying a car as is, are you going to pay as much as going to Furman Chevrolet that has a pre-inspected, pre-loved car with a year-long warranty on it?
Heck no.
Which car is worth more?
Furman's, the one from the.
I will pay more for the comfort of knowing there's a warranty behind from the seller to me. Right. And as is contract goes. So a bank foreclosure, they sell as is because they have no knowledge. They don't want to get sued no, it's as is. I'm not making any representations or warranty whatsoever. You're buying a pig in a poke. So I understand you're going to pay less. Does everybody think you're getting a foreclosure for a deal? Yes. Are you? Maybe, maybe not. But the seller's protecting themselves with an as is contract saying, you can't come back at me, you're as is. Now, it doesn't relieve them from the duty to disclose. But I'll be damn sure when you do a foreclosure sale, there's a whole bunch of we've never lived in the house. We know nothing about the house. We're not disclosing anything because we don't know anything. You can't sue us if we find something out later.
Absolutely right.
Right. That is worth less. That house is worth less than a house where the seller is on the hook for telling you the truth. Kimberly wrote, example, removal of large TV mounts, leaving large holes. This one has not been tested in the court system yet, to my knowledge. All right. So we talk about fixtures. All right, I got a TV. I got a 75-inch TV on my credenza. It sits on a stand on my entertainment center. When I sell the house, is the TV included?
No, because it's not attached to the
I
house.
unplug it from the wall, I take it off.
Yeah.
Now, if I mount a big TV frame arm swing thing with a big 3/4 inch bolts that nail into the header boards and all that shit, is the TV included?
No, the mounts are.
So that has not been tested yet. I would argue with you, the mount is attached, the TV is not. So as a good agent, what would you do?
Tell the seller to leave the mounts.
Clarify it in the contract.
Yeah.
TV wall mounts and TVs are included. TV wall mounts are included. Many wall mounts are universal and will fit any TV, right? But if you're going to take the wall mount off the wall, you're going to leave me with holes like this. If you did them right in the first place. If not, you might have 2 or 3 or 4 because you missed the stud when you did it the first couple of times, right? So the way around the ambiguity is to specify in your offer. So we have personal property. If you're unclear if a TV is personal property or not because of the mounting situation, write it clearly in. TV mounts and TVs shall remain.
Yep, it's absolutely. Yeah.
Absolutely easier to leave the mount and buy a new one. But make sure, because the buyer might be thinking they're getting the TV too.
Yeah.
And who the hell wants a 4-year-old TV? It's obsolete by now. It weighs 18 pounds more than the one from 3 years ago. So,
Yeah.
All right, Deborah, I took way more time than I thought. Boat lifts are the same situation. Don't assume a boat lift conveys. Is it attached? I would argue yes, but clarify it. Sellers don't always know. You're much better clarified. All right, Deb, you want to talk about some trust issues with listings?
Yeah, go and share your screen. I'm going to pull one up real quick because this will be easier to show.
Share my screen or share your screen?
Well, I need to share my screen.
Oh, you should be able to.
I can. Okay, good. Okay. What I want to talk about today, because we deal a lot with trust here, probate, trust, wills, all that stuff on a daily basis. And I've pulled up a couple, and this one is on a house here in Sun City Center. It's on Tahoe. And we were on the buyer's side, and the buyer decided not to move forward with this for probably a good reason. Now you see when you pull up in Hillsborough property records, there's 4 names on here. Lauren has a life estate. John Scott, James Howard, and Lori Jane Boatwright are all on here too. But you've got to dig a little deeper, because that does not really tell you who can convey the title to this house. If you go down to the last time it was, here we go. The last time it was sold or updated with some type of a deed change. This one was done 3 years ago in 2018. This clarifies. Now, this isn't the end all. This is the beginning of your research if you come across trust and stuff like this. All of these documents say the same thing. You see they're on the same date, same time, so you can just pull up one of them. They all say the same thing. This happens to be Lauren is alive. He is a single man whose address is on Lakeshore Villa in Tampa. As a grantor to the Lauren Collins for a life estate. Okay, he's his own trustee for the life estate. That's great. He has, without any liability for waste, and with full power and authority in said life estate to sell, convey, mortgage, lease, or otherwise manage and dispose of the property described herein is in fee simple, with or without consideration and without joinder of the remainder men. Okay, those other 3 names are the remainder men. They don't have the right to sell this property without him unless he passes, and with full power and authority to retain any proceeds generated thereby and the remainder to the 3 kids. Basically, these are 3 kids, okay? Well, Lauren is in assisted living, so we had a hard time getting the contract to him, but but we originally started talking to Lori. Lori told us she had her dad's authorization to sign the contract for him. No, she doesn't. And this is why. Now, if you have any confusion on this, send it over to the title company, let them look at it, let the underwriters look at it, and they'll direct you on who has the right to sell the property. This is really clear that Lauren can sell this and keep the proceeds without the kids. When you go back to the title on the property, it looks like all 3 of these should be on title. So we had to ask the title company, and they said we only needed to put it in the Collins Lauren life estate when we were making the offer. We didn't have to add these other 3 people because they're the remainder men to that.
I love all this, and I think it's 100% everything Deb said is right. Don't second guess yourself. In every case, go to the title company.
Absolutely.
Say, who does this? Because I don't want you making this determination. I get confused on this stuff too.
Yeah, I mean, because I'm reading it looks pretty clear, but I still send it over to Paramount and say, please make sure to tell us what we can do with this and who can really sell it. And does Lori have the right to sign for her father? No, she does not. And then she said she had power of attorney. Okay, this is a trust. You can never have a power of attorney for a trust. Understand that. And the kids don't understand this. Family members don't really understand this. They may have.
That's true.
Yeah.
The trustee would sign for the trust.
Yes.
But if the trustee was disabled, they could have a power of attorney signed for the trustee, I think.
No, they can't. I did pass this. So it's still set up in the trust, and in this case, it didn't say in case I'm incapacitated, then my remainder men can sign. So you will see verbiage in some trusts that says that. All these trusts, none of them are cookie cutter. It's going to be designed by an attorney with the family at the time and then recorded in the county.
Well, let's talk about this too, because a lot of times the couples from New York and the New York attorney write the trust for the Florida property. And many cases, the trust for the Florida property is not valid in Florida because it wasn't drafted the right way. And we've had that happen a lot.
A lot. Now, here's a big way to check that, because this was done in Delaware or something too. If you do not have 2 witnesses Florida requires 2 witnesses, okay? State of Florida does. Most states don't. Most states require 1. If it doesn't have 2 witnesses, Florida will not recognize the trust. So it's got to be done in Florida. So if it doesn't have 2, this one has 2 witnesses, it looks like. So, and the witnesses can't be the family members that are in the trust. They have to be somebody else. So please, as you're going through this and when you see this, the trusts are designed for a purpose. One big purpose is that it does not have to go to probate if a trust is set up. And the instructions in the trust tell us what happens when somebody passes or is incapacitated, then who can sell the property. Without any of that language, if it's just in Lauren's name, if this was just in Lauren's name and he passes, it's got to go to probate. And then we can't even list a property until it's through probate, unless we have a judge sign off saying, go ahead and list it. We'll hold the proceeds at closing until we settle the probate. That can happen. So there's so many avenues on this, that we can get into this more on a different day, because there's so many examples. But this was a good one because Lori was really trying to, be her dad's defender, but she has no right to sell this right now. So, so be cautious out there. Always send it to the title company to look at when you're looking at this stuff, and don't assume you know what's going on here. I never assume.
No, it's just too complicated with different states, and different rights and different laws. And where's this one drafted? And
yeah, there's another one where I've got real quick. It's real quick because I think that this trust was made in 1993. Do you think there may be another trust out there with a family that may not be recorded? This is so old. And both people are dead on this trust. Casimir and Gladys are now passed away. And on here, there's no remainder man. There's nothing. It's not really telling us much because back then they didn't put much in here. They just said they're the trustees for the trust when they're both dead. So now we got to go back to the family members, see if they've got a trust that hasn't been recorded to tell us if we can list this or not, or they need to get an attorney to really give us instruction and give them instruction what they need to do next. Because we see these old trusts all the time. And a lot of times we see new trusts come in after the fact that, oh, it's like, well, here's our trust. It wasn't recorded though, which can be a issue. If it's not recorded in the county, it may not be able to be valid.
well, here, I'll give you an example. So I'm a real estate broker, do a lot of transactions and stuff. I've had my attorney, Bob, over in Sun City. He did my wills and
He's
I have a
great.
trust.
Yeah.
I have no idea what my trust is for. There's nothing in my trust, but I have a trust. And he just acts like I know what it is.
Is
So
your house set up in the trust?
No,
Okay, then you don't have a trust on the house.
I have a trust. It's a
Yeah.
Craig Beggins irrevocable trust, nothing in it, but I've got one. So in his world, I've got a trust, but I don't know what it means. So my
Yeah.
point is, a lot of people go to an attorney who set up trust for them, but they never put anything in it, or they think it's
Yeah.
in there and it's not.
Yeah.
So these are real good probing questions to ask.
Yeah.
But you really need an attorney to guide you properly.
Power of attorney, one thing on power of attorney, there are 2 types in Florida. There's a medical power of attorney, which a lot of kids have over their parents. They think that is power of attorney to transfer title on their property. It's not. You have to have a durable power of attorney to convey title to a property.
And the power of attorney has to specifically state, has the
Yes.
authority to transfer real estate in Florida, or it does not work.
In Florida. And if the power of attorney was written in Ohio and it doesn't have 2 witnesses, it's not valid here in Florida. So you have to get a Florida attorney to write up a Florida durable power of attorney.
So here's a question for you. Is it better to find this stuff out at time of listing or after contract when you're getting ready for closing?
Prior to listing it.
Yes, 100%. These are
Yes,
questions
yes,
prior to
right.
listing.
Always, because the worst thing is and that's why we dove into this other one, even though we were on the buyer side, it looked really strange to us. So we had really our title company look at it. And, she was insisting she could sign, she can't. And we were able to
Great
get.
point, Deborah. So there it is. So the new broker has a new agent who says,
Yes.
it's fine, just go list it.
Yeah,
And somebody with experience goes, this isn't my problem, but we're
Yeah.
the buyer's agent, but does your seller have the right to sell?
yeah,
And they're going, I don't know. Duh.
that's- yeah. Well, they
Right?
said they got a trust. There's a trust here in, in the county, and it's like, but it may not be to convey title. So always get other eyes on this stuff for yourself. Don't assume, never assume. There's no cookie cutter in any of this.
Yes,
They're all
don't
different.
assume, and don't be a pompous ass about it either. Don't assume the other person's an idiot. Just be
No.
aware they might be an idiot and walk carefully.
Yeah, and share the information with them when you get it. Say,
Yep.
here, this is what I found here. This is good information for both of us.
Got it. All right, we're 5 minutes over time, guys. It's Happy Friday. Enjoy your weekend off, right?
Yeah, right. Call me this weekend if y'all need me. Have a
All right,
great
guys.
time. Great weekend.
Thank you for attending. Happy Friday.
Happy Friday.